Exciting. A lot of family members here on all kinds of sides, ready to have some good discussions. We will begin as a subcommittee until the other members arrive, and they'll go ahead and begin with a quorum. But for now, we're going to go ahead and begin with Assembly Member Calderon. Please step forward. Are you ready?
Thank you, Mr. Chair. Mr. Leno. AB 676 will help end discrimination against unemployed workers as they re-enter the job market. Employers and employment agencies will be prohibited under this bill from affirmatively asking an applicant to disclose information concerning the applicant's current employment status until the employer has determined that the applicant meets the minimum employment qualifications for the position. Studies have found that the long-term unemployed are discriminated against in the application process, including one that found that long-term unemployed workers with otherwise identical resumes were called back for interviews at rates 45% lower than the short-term unemployed. AB 676 will also prohibit employers, employment agencies, and persons operating a job posting website from publishing an advertisement or announcement for any job that includes a provision stating or indicating that an individual's current employment is a requirement for the job. Although California's unemployment rate continues to fall and economic conditions are improving, this is not translating to the long-term unemployed here in California. A Princeton study found that only 11% of those unemployed for more than 6 months will ever regain steady full-time work. Thank you. Appreciate your time and respectfully ask for an aye vote.
Thank you so much. Thank you. And again, if as members begin to present, we'll have two folks in support, two people in opposition, and we'll just start going through the process. Try to limit the comments to 3 minutes. I'm sure they won't take that long, but as I'm sure some bills will. So please proceed.
Mr. Chair, members, Caitlin Vega for the California Labor Federation here in support. What we found when unemployment was at record levels was that employers began advertising specifically saying that the unemployed need not apply. That's completely inappropriate and obviously creates an obstacle to workers being able to find their way back to jobs. All this bill does is ensure that unemployed workers get a shot at a position. Nothing prevents an employer from looking at the job record and talking to previous employers. All it does is get them a foot in the door, which is essential to us having a full recovery and to workers having the chance to be able to support their families. Thank you.
Great. Any other, yes, please. Any other support?
Very broad on behalf of
Hold on for a second.
Very broad on behalf of the Teamsters. Is it on? Yeah, okay. In support of the bill.
All right, thank you.
Mr. Chair, members, Deanna Johnston on behalf of the California Nurses Association, also in support of the bill.
Great, thank you. Anybody else in support? Any in opposition? Seeing none, any questions from members? Now that we have another member, we'll go ahead and establish quorum, if that's okay. Madam Chair, Secretary, please call the roll.
Mendoza?
Aye. I mean here.
Here. Stone?
Here. I'm ready to vote aye.
Stone here. Jackson? Leno? Leno's here. We have a quorum.
Mr. Chair, I vote the bill.
Oh, there you go. We have a motion for the bill. Any questions before we let the member close? Go ahead and close.
I appreciate your time and respectfully ask for an aye vote.
Madam Secretary, please call the roll.
The motion is due pass to judiciary. Mendoza?
Aye.
Mendoza, aye. Stone?
No.
Stone, no. Jackson? Leno?
Aye.
Leno, aye. Mitchell?
We have enough. Well, we're going to leave it open to other members to come on and add on and get your bill out.
Thank you, members.
All right. Next one. What's the next one after that? Anybody here? Lucky? Yeah, Lucky. Lucky. Member Lucky? Please step forward to the next one. I did order a larger room, but they said they're doing the schematics to expand this room to that side and expand the room this way. And we'll be waiting for a little bit on getting a bigger room. So, but Member Lucky, please proceed.
Well, thank you, Mr. Chair and members. I have the pleasure of presenting to you AB 272, which clarifies that reserve peace officers are employees with protections under the Fair Employment and Housing Act. Currently, without the protection of FEHA, reserve peace officers can be discriminated against because of their race, sexual orientation, or any other personal traits. In 2013, in the case of Estrada versus Los Angeles, the California Court of Appeals found that reserve officers are merely volunteers. This court disregarded Labor Code Section 3362.5, which defines them as employees. Then in 2014, Governor Brown signed into law Assembly Bill 1443, protecting interns under FEHA. However, this bill did not protect reserve peace officers from discrimination. Even if Estrada case established them as volunteers, today interns have more rights than a reserve officer. Reserves are considered employees by the California Workers' Compensation Law, the California Government Claims Act, the California Penal Code, and the California Commission on Peace Officer Standards and Training, regardless of whether or not they're compensated. AB 272 creates uniformity in the law and ensures that these officers are protected from discrimination and harassment in the workplace. And I have with me Mr. Renee that would like to follow up.
Thank you, Assemblymember Lackey. Good morning. My name is Jim Renee, and I am currently a Reserve Police Sergeant with the San Fernando Police Department. Prior to my current role, I was an LAPD Reserve Officer working patrol in the San Fernando Valley, Los Angeles County. I'm also a General Counsel for the California Reserve Peace Officers Association, representing the interests of 6,000 Reserve Peace Officers in the state of California. I'd like to give AB 272 some context. I'd like to take a moment and explain the journey of a California Reserve from the moment we decide to become reserves. From that time, it is a long, arduous road to becoming a California Reserve Peace Officer, and we are treated in all material respects as an employee by our agencies and by law. Both the Government Code and the California Commission on Peace Officer Standards and Training, POST, set forth the rigorous requirements for us to become peace officers under California law. We are subject to the same hiring, eligibility, and training requirements as full-time peace officers. We have to fill out a 30-page personal history form. We have many, many tests, oral interviews, written tests, background check, and polygraph exams, physical agility requirements, medical exams, psych exams. And once we pass all of that, we get to attend something known as an academy, which is months of training, nights and weekends, putting stresses on our families, our spouses, our partners, and our jobs, our full-time jobs, with no certainty of actually passing the academy. Once we graduate the academy and are appointed to our positions, we are assigned to the full service of general law enforcement activities, in my case, patrol. Once appointed under Penal Code Section 830.6, we are fully certified and sworn peace officers and are sworn to put our lives on the line every day protecting the citizens of the state of California. Which brings us to the topic of the Fair Employment and Housing Act, FEHA, which you know serves a noble purpose, mainly to protect workers from adverse employment actions due to discriminatory or retaliatory purposes based on being in a protected class. FEHA does not contain any statutory definition of employee and therefore looks to the common law for guidance. A recent case, the Estrada case mentioned by Assemblymember Lackey, misapplied and misanalyzed California law, most notably with regard to 3362.5, which it held did not apply. In fact, it just simply ignored 3362.5 in its entirety and looked instead to the volunteer exclusion of the workers' compensation statute. For that reason, we are here today to have the legislature fix that. As to the legal status of reserves, California law already defines us as employees, not only under 3362.5, but under the Government Code, the Government Tort Claims Act, for instance, which protects us in our acts as peace officers and also protects cities. If we were just volunteers, we would not have coverage under the Government Tort Claims Act, and I doubt that the agencies would want that to happen. 3362.5, as I mentioned, the Penal Code and post regulations themselves also define us throughout those materials as employees. And then there's the doctrine of respondeat superior, as I mentioned, where an employer is responsible for the acts of employees, which I assume if we go out and do something we're not supposed to, our agencies will be sued, and I presume we will be held accountable if we were mistaken in our actions. We are also given ID cards and badges. Our ID cards, this is mine, says an employee number on the badge, on the ID itself. At LAPD, this is the alphabetical roster of department employees. There's my name along with the other 10,000 sworn LAPD officers. The LAPD manual itself, which, by the way, the Estrada Court completely ignored, defines employees and personnel are used interchangeably and apply to any person employed by the department. These terms also apply to reserve officers while on duty. And finally, here is my post profile, and prominently displayed at the top is employment. So both under law and under fact, we are employees, and that's why this legislation is necessary today. Our opposition raises some arguments against this bill, including the liability argument. There are 6,000 of us, 3,000 or so are paid, so we're already employees. So we're talking about a class of 3,000 people at most, compared to the millions of people covered by FEHA every day. And secondly, and I think this is probably the most important part of this argument in opposition, if you assume liability will go up because we will be covered under FEHA, that assumes a couple things. One, and somewhat regrettably, that there's a basis for liability to go up, that there's discrimination occurring in the workplace, and that's exactly what FEHA is intended to avoid. And even so, what message would it send for this committee to not pass a bill which protects a group of reserve police officers who are sworn to protect the citizens of LA and other municipalities and counties and cities, simply because they would suffer adverse employment actions? That would not be a message that I would want the legislature to send. And finally, we also hear that reserve peace officers don't need these protections. Well, let's remember, FEHA was intended to prevent discrimination in the workplace. And again, I'll use this one hypothetical. Think of two gay police officers or two African-American police officers working side by side in a patrol car. One is a full-time officer, one is a reserve officer. Something happens, they get a sergeant who doesn't like the fact that they're in a protected class. Well, certainly the full-time officer has the protections of FEHA and has a remedy in case some adverse action is taken. Would we not want those same policies to apply to the reserve who works side by side with that officer and should not be discriminated based on being in that protected class? And for those reasons, I urge passage of AB 272. Thank you very much.
I appreciate your thorough discussion and a description of what you do. I appreciate that. I think for us it's very refreshing. For your next speaker, hopefully it won't be as long, but we'll try to. But you did cover a lot. It actually put the bill in perspective, so thank you. Please add on. At least your name and say you support it.
My name is Spencer Rhodes, and I am in support of 272.
Thank you, Spencer. Appreciate that. We'll have to, any others in support? Okay, we'll love to bring up the opposition if they're here. Okay, seeing none. Oh, I'm sorry. She's looking out.
Thank you, Mr. Chairman. Senators, Julianne Broyles here on behalf of the California Association of Joint Powers Authority. We regret that we are here in opposition to AB 272. We have spoken with the author and with the sponsors and tried to find some place where we could remove our opposition, but unfortunately that is not the case. Our core concern on this bill centers on the issue of the damages that we would be liable as public entity employers. CAJAPA is the risk pools that, of course, insure public agencies for employment and other types of benefits supplied to their employees. Under FEHA, it is only employees and applicants that are covered by that act. Volunteers, which the reserve peace officers are not employees under that act. I know why they would like to be considered such, but we think that it is not appropriate to take people who are community volunteers and make us liable as employers for the discriminatory acts that they believe have occurred. There are so many things in FEHA that add to those damage awards. For a risk pool, we pay for the cost of defense of a claim, but the damages must come from the city's or the other public entities' general funds. And that is something then that will be a financial hit to that city or locality or school, whoever employs that reserve police officer as a result. The claims right now that run in FEHA for an employer start off at about, on an average settlement level of about $200,000. Just the cost of defense is over $60,000. That's all from the Fair Employment and Housing Act at 50 study that was recently done by the Center in Law and Public Policy for UCLA and RAND. So it's a very thorough report and looks at that issue. We also will have to pay even if we lose, because there was another recent case, Williams versus Chino Valley Independent Fire District, that was decided by the Supreme Court, that says that the employer may not seek reimbursement for their defense fees from the person who's bringing the case. So you're going to have many cases brought. We will have to defend against. Those costs will have to come from somewhere, and that will be your public entity having to choose between defending that claim, paying the damages for that claim, and then unfortunately having to choose which program gets cut in their area for that. We have to emphasize these are people who are community volunteers. We wish that it was something different, but that's where we are. Unfortunately, our opposition can't be removed by any amendment that we've been able to find so far, although we wish it could be otherwise. Ask for a no vote.
So let me ask you a quick question. So the
Sure, sir.
entity that you provide the insurance for, which would be cities or whoever that pay into this pool, right?
Right.
Are they opposed to the bill?
Yes, they are. They have asked me to be here and speak in opposition to the bill.
Did they send a letter as far as a letter saying that they're opposed to this bill, or just through you?
They have communicated. They went out to their members of CJAPA. There are about 122 joint powers authorities that have anywhere from 50 municipal members to over 100. Some are smaller, like our smaller school districts that do employ reserve peace officers for DARE programs, drug intervention, education issues. All of those are affected by this type of a bill. Again, we wish that we did not have to oppose, but we do want to emphasize that the use of reserve officers will likely go down if this bill goes through, because the liability will go up, and we regret that that would be the case. But the real issue for us is the cost that we would take on through the liability under FEHA that is only meant to cover employees and applicants.
Yeah, I just think that, well, they do have, they're saving lots of money on having reserve officers and not paying full-time officers. That's nothing compared to what they're saving as far as having actual bodies in the street.
It will be that choice. I think the choice that many municipalities may look at is putting them on as full-time officers and taking them off the reserve issue. So I think there's that balance that has to be struck.
They should be on record, too. They should send individual letters from each city saying they're opposed to this bill.
We will ask them to do so.
Because I don't think it's, maybe members that are representative of that city, they go to the JPIA meetings and say, oh, we're opposed to it, but to go back to their councils and say, we're opposed to this, I would love to see that happen.
A lot of the large cities are permissibly self-insured. We usually have this, like San Francisco, like Los Angeles, San Diego. Those are permissibly self-insured cities. They don't belong to a JPA, but the smaller municipalities do, and we will do so and ask them to send individual letters.
Yeah, let's do that.
Thank you, sir.
Ms. Rose?
Yes, sir.
Yeah,
please, we do have a few other people that want to add on to this, but we could have some of the members ask questions. That'd be great.
So you do describe the nature of your opposition well. It's clear what you're communicating to us, but it does signify that, or suggest, you want to have it both ways, that you want the benefit of the volunteer service, but we're not going to be responsible for their being treated as we treat people here in California when they're employed. I have to ask, when we have expanded protected classes in FEHA, and I've authored some of those bills, did you oppose those bills because of additional potential liability if someone was found to be guilty of not respecting the broader aspects of FEHA?
On certain bills in the past, we have taken opposed positions, but we have found ways in some of them to find ways to accept that liability, specifically in the sexual orientation, the gender violence issues. We have found ways not to remove opposition on those bills, so it depends on the case.
And with regard to Assemblywoman Skinner's bill, that amended FEHA to include volunteers with regard to harassment. Did you oppose that as well?
I don't recall. I believe we did.
Right. Thank you.
Thank you.
Senator Jackson, sorry.
Yeah,
Thank you.
on a slightly different note, I'm kind of curious. Last year we extended, I think it was last year or the year before, we extended FEHA harassment protections to interns and volunteers.
That was the Skinner bill.
That was the Skinner bill, right. And that made sense to me on the basis that, you know, as we have more unpaid, we had more unpaid interns, and for a lot of those folks, having harassment on the job could really impact their future opportunities. So I'm kind of wondering, do people move from reserve officer to full officer? You know, is this sort of a stepping stone so that if they're harassed and leave the profession, it's a lost opportunity for them? You know, is this essentially the reserve officer? Is it a sort of a step on the career path? Is there a reason that we might, as we did with interns, want to protect them so that they aren't the victims of harassment? You know, a lot of people gave their time because they wanted to get a foot in the door, because during that period of time there were no other options. So they weren't going to get paid. Same thing with your reserve officers and so forth as volunteers. Is that part of what happens? There's a concern because reserve officers, sometimes that's the step to become an actual full-time officer?
It's actually both, and I'm sure Mr. Rennie can speak to this even more fully, but it can go both ways. It can be people who are looking to get into law enforcement. It can also be people who have retired or partially retired and are just keeping a hand in because they want to volunteer for the community. They love what they do. And we respect that and honor that in every way. But again, there's both.
Thank you. Appreciate that.
We'll go ahead and finish up some of the rest of the opposition. Go ahead.
Just Faith Conley with the California State Association of Counties. We're in opposition right now, but I wanted to thank the author and his staff for working with us moving forward. We're looking forward to working with them to possibly figure out ways to amend the bill to help ease our concerns about liability, like Ms. Broyles mentioned. So thank you.
Hi, Alicia Lewis of the League of California Cities. I'm mirroring the comments made by the counties in opposition, but still looking forward to working with the author on trying to find a pathway.
Thank you. And let me ask you a question. Do you get paid $1 a year or anything like that?
Our department pays us $100 a month, and it's really a stipend to offset expenses. I can tell you that we spend a lot more of our own money so there is de minimis payment. Some reserve officers are paid hourly, so they're actually paid employees. And others, like LAPD officers, receive $50 a month, again, defined as a stipend to offset expenses. There are also a whole list of indirect financial benefits that go with being a peace officer, both under federal and state law, with regard to line of duty death benefits, with regard to life insurance benefits, scholarship for children and spouses, workers' comp, as we mentioned, is specifically provided for. There's quite a list of other what is defined as indirect financial benefits should we be needing those for pursuing those interests.
The risks are still the same whether you're reserve or not, right?
I can tell you, yes, yes, sir. Yes, sir.
Imagine? Yes. Wow. Okay. Senator Mitchell.
I just have a general question. I don't remember the Skinner bill, and staff may be able to answer it for me. Are there other volunteer classifications or categories where FEHA does apply? You know, like Red Cross volunteers or volunteer firefighters? So I don't know but I'm assuming volunteer firefighters don't have peace officer status. So non-peace officer status volunteers, do we know if there are others where FEHA applies to them? Okay. All right. Thank you.
Thank you. Mr. Chair, oh, wait. We have any more comments? Okay.
Yeah, thank you, Mr. Chair. First of all, thank you, sir, for your volunteerism and putting yourself in harm's way on behalf of municipalities. I've worked with a number of reserve officers in my 22 years in local government in the cities and the counties. And frankly, when we had our economic crisis, we were not able to keep our levels of service up if it was not for volunteers like you. And, you know, the savings to local government and having volunteers, especially in the public safety arena, amount in the hundreds of millions of dollars. And you certainly deserve to be protected from the discrimination that we shouldn't condone with volunteers or employed people, for that matter. My only concern is, you know, and I'm hoping that the author, who I have a great deal of respect for, and it adds credibility to this bill because of his former service with the California Highway Patrol, which I thank you again, Mr. Lackey, for your service. He brings a lot of credibility to the bill, and you made some very, very compelling arguments why to support this. I still have concerns at CSAC and the league. I understand their concerns. I hope the author will continue to work with them, because the last thing I'd ever want is us to support a policy like this that would stifle, if you will, a municipality, a sheriff, a police chief from hiring people because of the fear of, you know, in a lot of litigation, which, you know, we're talking about 3,000 people. I think a lot of details as far as employment issues can be worked out between a sheriff, a sergeant, a lieutenant, and I think a lot of things can be mitigated. But I stand in support of the bill, and appreciate the author bringing it forward.
Thank you again. Any more comments from members? We do have a motion for the bill. Any final words, Mr. Lackey?
No, I would just ask that you vote in support of protecting reserve peace officers from discrimination and indicate by an aye vote. So,
And I agree with you. I think this bill is very necessary. We want to make sure that all peace officers, whether reserve or not, need to be protected against harassment and discrimination. I do think you are definitely an employee more so than a volunteer in all respects. So with that, I will go ahead and take a roll call, Madam Secretary.
The motion is due pass to appropriations. Mendoza?
Aye.
Mendoza, aye. Stone?
Aye.
Stone, aye. Jackson?
Aye.
Jackson, aye. Leno?
Aye.
Leno, aye. Mitchell?
Aye.
Mitchell, aye.
thank you very much.
I was out, 5-0. Next bill, sign-in order will be Senate Member Gomez. Please step forward.
Lisa, Lisa right there.
Since we do have a few other senators that are here, we're going to go ahead and lift the call on Calderon, item number 11, AB 676.
Senator, Mr. Chair, I'm wondering if there, during that discussion, I apologize for being late, was there any discussion about the veto that the governor had done on the bill last year and how this bill differed from that?
No, we didn't. That wasn't brought up.
Okay, thank you.
Yeah, that wasn't brought up. Okay, we're going to go ahead and lift the call.
The motion is due pass to judiciary for AB 676. Jackson?
Aye.
Jackson, aye. Mitchell? Mitchell, aye.
Okay. The vote is 4-1. The bill is out.